Hi, my name is Wan Ahmad Firdaus bin Muhammad Nazir. I'm from Kuala Terengganu and previously I took my SPM in SMK Paramidin, and then I furthered my studies to the Centre of Foundation Studies UITM Bengkel, and now I'm a second year LLB student in UNIZA. My aspiration in studying LLB is that none of us involved with the legal profession in my family. Thus, I feel like this is one of many opportunities for me to help my family and many others out there. The Movement Control Order (MCO) that was imposed by the government of Malaysia on March 18, 2020 was to help flatten the curve of the COVID-19 cases in Malaysia. Under the COVID-19 Act 2020, Section 7 of the Act stated on the inability of any parties to perform any contractual obligation arising from any of the categories of contract that is specified in the schedule of the part, and due to the measure prescribed, made or taken under the Prevention of the Control of Infectious Disease Act 1988 to control or prevent the spread of COVID-19 shall not give rise to either party or parties exercising his or their right under the contract. In my opinion, the implementation of the MCO may have caused the contract to be breached. However, we need to discuss it further. Firstly, about the force majeure clauses, it is a contractual clause that alters the parties' obligation and liability under a contract when an extraordinary event or circumstances that is beyond their own control prevent one or all of them from fulfilling those obligations. The effects of these clauses is depending on how the contract was drafted. It may excuse the affected party from performing the contract in whole or in part. It also delays performance of the contract or even provide the parties right to terminate the contract itself. But if such provision was not included, then the contract will become frustrated, as provided under the Section 57, Subsection 2 of the Contract Act 1950. For an agreement to be regarded as a frustrated, it requires three different elements, which firstly, the frustrating event must not be provided for any provision or the contract between the parties. Secondly, it must not be self-induced, and lastly, that the frustrating event has changed the circumstances to make the contract's performance radically different from what undertaken initially. Then the court must find that it is practically unjust to enforce the original promise. So, whether the event is mounting as a frustrating event is subject to the radical change in obligation tests, and depending on specific circumstances, in this case, the COVID-19 pandemic, it may have fulfilled the test requirement that it may render the contract as frustrated. Thus, I can say that the MCO implementation can cause the contract to be held as a breach. However, individuals who may want to make contract during this pandemic might have just taken a few precautions to include the force majeure clauses during the drafting process of the contract. We know that the pandemic may cause a contract to be breached, but can the affected parties claim for damages, right? So a parties may claim for damages under the Section 74 of the Contract Act. As provided under this section are two limbs, which the first limb is that the compensation to be received must be caused by the damage that naturally aroused in the usual course of things from the breach. The second limb is that the parties knew when they make the contract, it is to be likely to breach it. Thus, this two limb comes from the English landmark case of Hadley against Baxendale, and moreover, Section 75 of the Contract Act provide a similar function as to the force majeure clauses in the contract. That's what I can say is a party that suffered damages from the MCO or from this pandemic, they might get the compensation under these two sections. And with that, I rest my case.